So we are going to be streaming in about 15 seconds.
Now streaming.
All right. The Supreme Court of Guam is now in session. Will the clerk please call the case?
This is Supreme Court case number CVA19-010. In re Roderick M. Wilson II, plaintiff appellant versus Jennifer J.V. Wilson, NKA Jennifer J.C. Villagomez, defendant appellee. Appearing for the plaintiff appellant is attorney Delia Wolf. Appearing for the interested third party, Office of the Attorney General, is attorney George Valdez. Defendant appellee Jennifer Villagomez did not appear in the appeal. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Wolf reserves 10 minutes.
Thank you, Madam Clerk. Attorney Wolf, you are now recognized. Please proceed.
Thank you. May it please the court, plaintiff appellant Roderick Wilson raises 3 issues on appeal. And the first issue concerns the lower court's error in holding that child support could be ordered effective nunc pro tunc for the period from the date of the filing of the complaint in 2009 to the date of the first child support order in October 20, 2014. Now, the legislature of Guam has set forth public policy in 5 GCA section 34105A that child support orders be fair and equitable. This Supreme Court has held in Palomo v. Manglotnia that with this policy, fairness and equity must be taken into account when determining support orders. Consistent with the legislature's public policy that orders be fair and equitable, the legislature has authorized child support awards with limits. As to child support orders that are continuing, that are prospective in effect, one of those limits is found in 5 GCA section 34116.1, which provides that in a case where there's never been a child support order, the first child support order may be made effective nunc pro tunc to the date of the filing of the complaint, but not exceeding 1 year. And so that means that only the first child support order can be made effective to an earlier date, and that earlier date can be no more than 1 year prior. In this case, the very first child support order.
Ms. Wolf, can I just ask one question? Is there a distinction between a order of support and a reimbursement for costs when a support order has not been entered?
Yes, those are separate. That's separate relief, separately enumerated in section 34105A. Reimbursement of the cost of support covering the period prior to the filing of the complaint is authorized in section 34105A8, whereas a continuing order of support with prospective effect is found in section 34105A2, and that is a continuing order of support. And so there is a difference, there's a distinction separately enumerated. There are different kinds of relief that the legislature has authorized in child support cases, one for reimbursement and the other for continuing child support going forward. And only the very first child support order can be made effective nunc pro tunc to an earlier date, and that is to not exceed 1 year prior. In this case, it's undisputed that October 20, 2014 is the first child support order issued in this case filed in 2009. And
Why is the case filed in 2009? Why isn't the case a 2014 action, since that is when the department brought the action?
this case is the case number. This case was brought. It was initiated by the plaintiff, my client, when he filed a complaint for divorce in 2009, and the defendant, Jennifer Wilson, now Jennifer Villagomez, never filed an answer or otherwise defended herself. And despite that, 5 years later, in 2014, when my client filed a request for a substitution of counsel with the intention of obtaining visitation with his son, the Attorney General made its first appearance in this case. And
So why is that not the triggering date for 34105A8? Because 34105 discusses the department bringing an action, and A8 references the commencement of the action. And so why isn't the relevant period for looking at recovery for reimbursement of support the period before the period of time, before the department brought the action in 2014? I don't necessarily see why the divorce complaint, which is not the department bringing an action under 34105, is relevant for purposes of determining when you can recover the reimbursement of the cost of support.
And yes, that was an argument that we had raised, that the action was brought in, or for purposes of determining the 6-year period, the 6-year limitations period in Section 34105A8. The relevant time frame was the Attorney General's appearance, and if that is the case, then that would mean that there would be no support. No reimbursement that could be awarded prior to the Attorney General's entry into the case.
Why?
Why
was that?
Let me ask this, since we're focusing on the Attorney General's entry. I'd like to focus initially, and then we can get back to this, because you argue that the Attorney General has no standing. And standing is a jurisdictional issue. And so I think that needs to be fleshed out prior to the substantive arguments. And you raised this, that the Attorney General should not be even arguing this case. But it's difficult for me to see how we can discuss standing without discussing the traditional standing requirements. We set out in INRE GIAA 2019 Guam 6 that traditional standing requirements expressed in Article 3 apply to all claims asserted in Guam courts. And we know it as constitutional standing or common law standing. And there is a 3 elements test. And the first one, of course, is the main component, and that is that the plaintiff must suffer an injury in fact. And so I think there needs to be some type of discussion, if you're going to raise standing, that the Attorney General's office should not even be arguing in the case. And I think my first inquiry is you go through the statute of 34105 and its enumeration, and you say that the AG is not authorized under any of those provisions to bring the action that it did. Are you conflating causes of action as to whether or not the Attorney General can pursue a certain cause of action, and confusing that with the requirements of standing?
standing of the AG's office is set forth by statute, and the statute, the relevant statute for child support is Section 34105A, which lists the kinds of relief concerning child support that the AG can seek on its own or by entering an existing case. And none
Well,
of the relief.
we kind of rejected that in reference to INRE GIAA. And we said that it's within the legislature's authority to prescribe by statute the injury in fact in which that the legislature can provide in certain instances the injury that is sought to be utilized for purposes of establishing the first element of our constitutional traditional standing requirements. And we said it applies to all cases. So I can understand the argument that you may be making that the statute provides the injury. But then the question is that exclusively the only manner in which the Attorney General can or cannot assert that it satisfies the first element of the constitutional standing requirement?
I believe it is because the standing of a government entity, I believe, derives only from statute. And in this case, the Attorney General's office is not acting necessarily on its behalf. It's to act in the best interests of children, and it's to represent the government of Guam in doing so. And so that was another issue that arose through the course of briefing, and that was that in filing a response brief, the Attorney General actually represented that the brief was made on behalf of the parent, the mother, the defendant.
But it seems pretty clear when the trial court admitted the Attorney General when it entered its appearance in August of 2014, and it submitted that it was entering its appearance on behalf of the people. That seemed to be pretty clear from the entry of appearance hereby the Attorney General. I'm reading from the entry of appearance document, August 13, 2014. The Office of the Attorney General, Child Support Division, hereby enters its appearance as Attorney of Record for Guam in the above entitled action for the sole purpose of establishing paternity and or providing child support enforcement services under federal and Guam law. And then it cites the statutes that you are alluding to. So I guess the question, and that maybe Mr. Valdez can assert, is if you, as you contend, there needs to be an order for purposes of the AG asserting an injury that it can pursue in order to have standing in our courts, is 34105A, and the provisions there, the exclusive provisions within the child support statute regime in which the AG can assert that it has, number one, a cause of action, and number two, an injury if standing is challenged, which is what is the focus is as a main argument on your appeal.
I would say that that the standing to look to for determining the AG's standing, we look to Chapter 34 of Title V, and looking at the entire chapter, it's clear that the legislature did not authorize the Attorney General's office to seek a child support order beyond 1 year prior. The legislature made clear that the AG's office has standing to seek support for the period before the filing of an action, and also to seek a continuing order of support but it's set forth in that very same chapter limits to the continuing order of support that can be ordered or could be obtained. And so by the AG disregarding the limits of the relief that it could seek, the standing that the legislature has provided it concerning continuing support orders is acting beyond the scope of the authority granted by the legislature.
I suggest that you may be conflating whether or not the AG can pursue a cause of action, and as opposed to whether or not the AG has standing. And standing also includes a zone of interest in which maybe the statute is not specifically enumerated, but if it's within the interests sought to be protected. And here the AG is trying to enforce child support orders that you may want to think that 3104, 105A and the specific provisions in there are not exclusive. But you can think about it, and you can get back to Justice Storrs' inquiry. I just want to point out.
Let me just follow up on this issue. As she's focusing on the statutory authorization and the claim that they're only limited to pursuing, specifically prescribed statutory authorizations as opposed to a broader general standing issue. But what about the application of 5 GCA 34-108, which gives the department the ability to enforce any child obligation provision described in the chapter for those who aren't receiving aid to dependent children, under the aid program for indigency? So that doesn't seem to have the same limitations that you suggest, that they can only pursue if it's for an award of support. There's no limiting language in 34-108. And it says that they can make any services and enforcement of child obligations for it, and they get to represent the non-recipient spouse or child in the same manner as the recipients, and they're meaning recipients of the aid. So why doesn't that provision give the statutory authority, putting aside the question of the AG's standing in general standing principles?
Well, this is a section that the Attorney General's office has not cited as authority to seek the relief that it seeks beyond Section 34-116.1. I believe that this section concerns the Attorney General's office's authorization to provide services to non-recipients of aid. And
right.
So it's clear
in this case, there's no allegation that Ms. Villagomez has been a recipient of any public assistance. And in fact, you made that point when you were arguing that the provision of 34-105 A2 or the provision within 105A for application of support, that this was not a question where there was a financial or public assistance that was being provided under 6, that to recover amounts that they received from public assistance because of the separation or desertion of the parents. You said this is not a case where public assistance has ever been granted. So if that's the case, and if this is a situation where the AG has the authority under 34-108, why can't they continue under that, irrespective of the limitation in 116?
The limitation in 116.1 is not limited to situations in which government aid is provided to either parent. It makes no difference between those situations of government aid and non-government aid, it applies to all continuing orders of support. It states that when there is no support order, temporary or permanent, then only the first order can be made effective nunc-pro-tunc to an earlier date, not exceeding 1 year. And so 34108 simply permits parents who are not receiving government aid to apply for services to the AG's office, so that the AG's office could take action concerning support. It does not supersede any of the provisions of 34105A or 35105AB or any other provision in Chapter 34, especially concerning the limits of support orders. And so it's clear it's clear, and the lower court recognized that Roderick's interpretation of both 34105A and 34116.1 is in harmony. It is a fair interpretation. There are no conflicts in interpreting the statutes, interpreting support and reimbursement in this manner. The legislature was very clear as to the relief that could be granted. And the relevant relief here is a continuing order of support, and it could only be the first order, and not here, the fourth order, 5 years later, the fourth order, that orders child support arrears for the period from the filing of the complaint to December 2014. That is a blatant disregard and violation of the limits set forth in Section 34116.1, which only allows.
Let's go back to the commencement of the action, because I don't think we really got a chance to resolve that issue. Your argument is that the commencement of the action contained in 34105 is the date of the filing of the complaint, even though the statute says is referencing an action that the department brought. And in this case, the action that the department brought wasn't started until October 2014 or August 2014 was when they brought the action for the child support. So we have to reconcile what is the commencement of the action date. You're saying it's the date of the divorce, and the 34105 discusses it in the context of the department bringing an action. And then if we go to 34116.1, is it possible, I mean, if you look at that provision, can there be more than one action, more than one complaint that might be relevant for purposes of determining a nunc-pro-tunc period? So for example, in this case, there was an action for divorce filed. And at the time the action for divorce was filed, there was no order for child support provided, even though the complaint prayed that no one should pay child support. Neither of the parties would pay child support, and they'll just support them independently. The judge entered no order. And as you correctly point out, there was no order entered by the judge at the time of the divorce decree for support. I think that if the judge had said each of the parties will pay support, one could maybe say that was a support order, but that wasn't the case here. But then subsequently, there's an action for child support. It is filed in the context of the divorce proceeding, but there's an action for child support. So when we're talking about the filing of the complaint there, should we be focused on the filing of the child support complaint, the action in the child support matter, even though it's filed under the same domestic proceeding case, so that you look for that period for nunc-pro-tunc application? Why should we be rigidly focused on just just the timing of the divorce and not look at the time that the child support action was filed?
Well, I would like to say that Section 34105 is not limited to the actions brought by the AG's office, but also it also involves actions in which the Attorney General's office joins in. And so the AG's office can join in an action already in existence against the persons who owe support. And so,
in answer to Justice Torres's question, if I understand what you were alluding to as far as the term commencement of the action, as you pointed out, 34105A provides two instances in which the AG can pursue its support enforcement. One, it may bring an action in its own name, which is not the case here, as I understand it, or it may join in an action already in existence, which seems to be the case here, because when it entered its appearance, it did it in reference to domestic case 381-09. So does it make any difference as to how the AG pursues its action for determining when the commencement of the action should be and how it's determined?
it makes no difference for purposes of this appeal, because this appeal does not concern the cost of reimbursement, the reimbursement of the support for the period before the filing of the complaint. It does not concern that. And what it does concern is the first child support order. And that is the
But
only...
it does, if we determine that the action was commenced in 2014, then it relates to that period. If we say the action was commenced in 2009, then it would not relate to that period. So I think Justice Carbolito's question is important. Does it make a difference, and should it make a difference if the AG brings a separate action and then is able to recover the costs of support at the time it files its action in 2014, or if it joins an existing case that was filed many years previous, that the AG it can only recover the costs of support at the time that earlier action in 2009 was filed? I mean, I'm trying to understand why there should be a distinction and what would be the rationale for treating it differently if the AG brought the action independently, or if they just happen to do it for comedy and convenience and other reasons in the existing domestic proceeding case.
I just want to make it clear, because the lower court confused the issue that was being raised by the plaintiff. And the issue that we're raising is not a challenge to the cost of reimbursement for the period before the filing or the commencement of the action. We're appealing the award after an order, the lower court's finding after the first child support order is made. This is not even an appeal of a first child support order going beyond 34-116.1. This is an appeal of a later order, which turns out to be the fourth child support order that tries to cover child support arrears for the period before the first child support order. And so reimbursement, the time of commencement of the action is relevant to determining whether or not reimbursement for the period before the filing or commencement of the action can be obtained. It's not always going to be obtained, because the court has authority, even to discretion to award that. But we are not challenging that. And in this case, the first child support order, even if it could have made an award, nunc-pro-tunc to an earlier date, did not do that. And an entry of appearance has never been, I've never seen any case law where the entry of appearance is synonymous with the initiation of an action, which is a lawsuit and the filing of a complaint. I haven't seen that, although, we made that argument previously. We lost on it and we did not appeal it. But assuming
so your
that
entire argument is focused just on the ability of the child support referee in 2018 to enter an order that would go retroactive to a period of time to 2014 when the first order of support was entered. That's what you're telling me the whole issue is on appeal?
The first and second issue concern that. The third issue concerns the lower court's ability to retroactively modify that very first child support order 5 years later. And so,
okay. So getting back to the 116.1 issue then, I asked the question, can there be more than one effective date in 116? You have an effective date for the when the filing of the complaint for divorce, and then you have an effective date when there's a child support action that's brought, a complaint that child support's not being paid. Can you have more than one effective date depending on what the action is that's being filed?
I don't believe that different dates can be used. Assuming it, in my practice, I've seen that there can be a divorce case where child support is part of the relief requested or discussed, and the AG's office files a separate child support action. That's not uncommon. And so even in those situations in which there are two different case numbers for the same issue of child support, the relevant time frame to look to when the action was filed, I would submit that it would be the earlier of the two cases. It's whether or not there is an action that was filed by the time the child, before the child turns 6. And so again, that one is only for reimbursement of the cost of support. That's not a part of this appeal. But 34-116.1 is not concerned about when the case was filed. It's concerned about the first child support order and how far back it can be made effective. It's a continuing order.
Ms. Lott, I like to focus on that first child support order because your argument really hinges on that in terms of the ability of the trial court to modify that as that quote unquote order, that everyone that the referee, the trial court, the AG all disagree in reference to your description of that seeming order that came out of the October 2014 hearing. Your contention is that order of payment of $200 constituted the first temporary order of child support, and it was constituted a final judgment under our case statutory scheme, and that therefore certain consequences flow from that. And this is where I'm having problems, and just in terms of trying to resolve it in my mind, because the trial court, the referee, the attorney general said that there was really never any order that came out of that hearing, and I think the trial judge, said it was just a stopgap, an ephemeral thing. And so it was always with the intention that they were going to go back, do the calculations, and then come out with a temporary order as contemplated by the statute. So the difficulty in my mind is that I'm trying to resolve, and I think is very pivotal in a position I take, is reference to your description that $200 support payment constitutes a temporary child support order. So I'd like for you to focus and the reasons why you feel that when they didn't have any deliberation, stipulation, calculation, but just maybe some voluntary support on the part of Mr. Wilson to pay $200 because that's what he had been paying before when there was this informal arrangement, how that then all transformed into this temporary order with legal consequences that arise out of it.
So yes, the very first child support order was the October 20, 2014 temporary child support order of $200. However it was obtained, whether valid or invalid. If any party, including the Attorney General's office, believed that the court wrongly entered the order without following child support guidelines, or then it had the power to immediately file an appeal, or it had the power to immediately file a motion to modify so that would stop the clock. And so did any of that happen? None of it happened. And so
was there any indication, oral or written, that $200 support payment constitute an order of the court?
There was no order that was issued on its own in writing. It was recognized, it was issued orally from the bench. I believe that it might be contained, it might have been issued separately. I do not have that, but Chapter 34, child support, provides that child support orders need not only be in writing. They may be effective from, when it is ordered from the bench orally. And so once there is an order of child support, that becomes a final judgment that is immediately appealable.
See, but I didn't see any reference to the record where you pointed out in your brief that the $200 payment was ordered from the bench orally, and therefore this constitutes the temporary order of support. I was looking for something where there's some formalizing rather than just continuing on the voluntary action on the part of Mr. Wilson to pay this $200. And does that mean that it then constitutes a temporary order of support?
I believe that I'm looking for it now. I apologize, but I believe that there was acknowledgement that the $200 was the first or was issued on October 20, 2014. I believe that the referee acknowledged it in findings that she made, and that was also acknowledged by the lower court in the decision and order. I can locate that. It should be a part of the record. I believe it is in excerpts of record at 49, the decision and order. There is reference to the temporary child support order requiring Roderick to pay monthly the amount of $200 going forward. So I believe on page 49 of plaintiff's excerpts of record, there is reference to this first child support order. And it's on paragraph 10. During the October, sorry. So yes, it is there. There are even excerpts from the hearing on October 20, 2014, and the lower court acknowledged that that this was an order made by the referee of $200 monthly. Now, if this were to be, let's say, an invalid order that could somehow be revoked, even though nobody has challenged this final judgment ever, no one has, and so, and this, there should be finality as to this final judgment years later. Even if that were to somehow be voided at this late stage, then the very first child support order would have been in 2017. And that our argument would be that order, that first child support order, could only be made effective no earlier than 1 year prior. So no earlier than 2016. Now, again, we're not necessarily arguing that because we believe that the first child support order is undisputed to be the October 20, 2014 order. And so, but if that were to be the case, then we could not go back in time to create a new order that complies with the child support guidelines. There's just no authority for that. Then the first child support order becomes, was issued years later in 2017. And that would still be subject to the limits set forth in section 34.116.1, which is clear that parties should act with haste. Once a case is filed, the courts will not tolerate parties sitting on their hands and allowing the clock to run. Parties must act efficiently. And I cited a case, I believe it was Santos v. Carney, in which the court stated that a 13-month delay justifies dismissal under Rule 41. In this case, we have until from 2009, the filing of the complaint, until 2014. So the first child support order. Now, we're not advocating the case be dismissed, but we're advocating that it makes sense for the legislature to set a limit as to when the child support order should be made effective to. And that's a reasonable limit because it allows parties to understand what their financial picture is and to act accordingly. And it pushes the parties to move.
Attorney Wolf,
Usually,
I need to interrupt you at this time. It appears like if I see the clock, I have not been looking at the clock, but you've gone 10 minutes over your 30-minute allotted time. Is that correct, Trina?
That's correct, Chief Justice.
All right, so I'm sorry, but I need to then interrupt you at this time, and I would like to recognize Mr. Valdez, and for you to commence your arguments. You are recognized at this time, Mr. Valdez.
Thank you, Chief Justice. Good morning to the panel. May it please the court. We have filed a brief as an interested third party in this case from the Office of the Attorney General, Child Support Enforcement Division. And as indicated by the questions and discussion going back and forth, clearly the major issue in this appeal is the interpretation of 34116.1. What does it mean? And the interpretation put forth by Attorney Wolf was rejected, as the court notes, by both the referee and Judge Berdalio in this very court. And her interpretation is that that statute is a limitation period. And she repeatedly states first order, as if that is a cutoff, where once an order is in place, whether it's temporary or permanent order, the court is therefore unable to go non-pro-tunc to the effective or the filing date of the complaint, which is not what the statute says. 34116.1 does not mention first order. It doesn't mention present order, but it says previous order. So if there is in cases filed after the effective date of that statute, if it involves minor child or children and involves child support for which there is no previous order, then the court can issue a child support order going back to the filing date of the complaint. And so it's not a limitation period that once an order, temporary as it is in this case, was issued, then all of a sudden you can't go back. And the part of the reason for that is it doesn't comport with the language in the statute. And a more reasonable interpretation is that the focus should not be on whether there is an order ever, not a first order, but it should be the focus on the filing of the case when it started. Is there a previous order? And so in this case,
34116.1, as pointed out by Attorney Wolf. I mean, when you say the focus should be there is which there is no previous order, but then it says parentheses temporary or permanent. And I think if that there was a temporary order that was issued in October of 2014, Ms. Lujan cites to the statute and case law that says there are consequences, and that's a final judgment. And the court is precluded from going back, if that is the case, from going back and modifying where it never appealed a temporary child support order that has the effect of a final judgment under our statute and under our case and under case law that she cited in California.
We acknowledge that there was an order, a temporary order. All the parties present during that hearing in 2014, that order was in place so that the obligee mother could receive payments as ordered by the court with the specific intention of correcting that in a matter of weeks. And so it was not, we agree with the Superior Court's description of it as a stopgap, because the alternative is no payments. And so if the court were to interpret this statute the way Attorney Wolf is advancing, it would first of all go against the policies of 34105, which is parents should support their children, and it would be resulting in an incentive for delays to benefit a party. In this case, there were significant delays in this case, and they all work to the benefit of Mr. Wilson if the interpretation of 34116.1 is adopted. And again, if that was rejected.
Is the policy that you are saying that we should follow, does that give us the authority to then, by judicial fiat, rewrite the statute in reference to what you're suggesting, that it's not fair, that it should be interpreted this way because it enhances the policy of that every parent should support their children, and that's paramount? Does that then overcome the language of the statute if in fact you say that you agree that there was a temporary order and there are other sections that have corresponding consequences? Are we then as the court that we just ignore that because the policy should be that every parent should pay whatever they can, whenever, and irregardless of what the statute language may suggest or may state?
No, that's not what I'm arguing. What I'm arguing is that the statute as written does not mean what Attorney Wolf is advancing. And again, this was rejected. And so coupled with that is the policy argument, but mainly this is a matter of first impression for the Supreme Court of Guam. This is something that's been, as noted in the briefs, it's been a struggle. What does this statute mean? And so Attorney Wolf is adopting one interpretation, which Judge Berdalio and the referee did not agree with, and our position from the child support officer, we don't agree with that as well. That it's a limitation.
And in not agreeing, I mean, Attorney Wolf seems to suggest one way of harmoniously reading the two statutes. And I read the trial court's decision and the AG's position, and we don't like that, because then that means that it may encourage parents to delay not agreeing to pay child support. There are all these inequities, and that doesn't promote the best interests of the child. But does that policy give us the authority to ignore the language and rewrite the statute so that it will accomplish these policies that the trial court and the Attorney General is advancing?
Ultimately, that would determine on the court's interpretation of the statute, which has not been resolved. And so to answer Your Honor's question, it would really depend on whether or not that statute is in effect a limitation, where if there's an order that does not go non-proton, that you can never do that again, which is what Attorney Wolf is arguing, that because there was a temporary order of $200 in 2014, the court is now unable, despite the language of the statute, which is in dispute, I would say, allowing a court to do that. And our reading of that statute is that, again, if there's no previous order, when a case is filed, the court may go non-pro-tunc to the filing of the complaint. And in fact, that is what happens in child support cases that are filed, whether we enter an appearance or a new child support case is filed. It can take months, if not years, as in this case, for the first order to be issued, whether it's temporary or permanent. And so if it's a limitation period, that would result in the inequities that have been noted. But I would advance that the statute does not have, that's not the only interpretation, and it can be read in harmony with 34105. 34105.
How do you reconcile that? If you say that there was a temporary order of support in October and you're not disputing that, then what is the meaning of section 34121 when you can modify orders? I thought that the argument was that there was no order, and therefore when there was a order of payment, or when there was a payment of $200 a month, it was only a stopgap until such time as the court could go back and get all the financials and then determine based on calculations, and then after that enter. But I hear you now saying that you're not disputing that there was an order of $200 a month, but that doesn't preclude the court from going back and modifying it 3 years later.
That's correct. There was an order. It was, however, it was a temporary order, and statutes in Chapter 34 do specifically mention child support orders can be temporary or permanent. And in section 34119.2, it's subsection C, temporary order of support may be revoked or modified. So the statute specifically allows for revocation or modification of temporary orders. Now, if a permanent order is in place, that's different. If a permanent order is in place, if you want to change that, then you must file a motion to modify based upon changed circumstances.
But what about the case law cited? What about the case law cited by Ms. Lujan? I'm sure look for the case that says that, you know, when an temporary order is entered, it's a final judgment, and and there are consequences. If you don't appeal it 30 days later, the court lacks jurisdiction to go back and modify it because it constituted a final judgment. That's your position seems to fly in the face of that authority, and you cite no authority where that case law should be rejected because for whatever rationale that it is not controlling.
I believe the case law, that issue or that question goes to the issue of the retroactive modification, and the case law, I believe,
that's her whole appeal. I mean, that's you heard her. You heard Ms. Wolf's argument in terms of framing her appeal in response to Justice Torres. That's what this is all about.
Yes, I would agree. It does go. The whole appeal turns on when to go back in terms of the imposition of child support, and so there's really 3 periods at issue. The first period is pre-action, pre-filing complaint, which I don't believe is in dispute. From birth to filing the complaint, I don't believe that's in dispute that Mr. Wilson should pay that. At issue is from 2009, the filing of the divorce action, to 2014, the temporary order of 200. That's 1 period, which is significantly at issue in this appeal. And then the 2 other issues are standing to seek that portion of child support arrears. And then finally, retroactive modification of the $200 temporary child support order. And so to address Your Honor's question, the case of Young Girl versus Moylan addresses motions to modify and when should it be effective, and it should be effective going forward. Now, in this case, as noted, there was no specific motion to modify. This case is unique in that instance, and so for purposes of a retroactive modification, I would state that it's specific to this case where the parties appeared at a hearing. There was a temporary order in 2014 of $200, not based on any calculation, unlike Moylan. And it was stated by referee Ingalls, I'll come back in 3 weeks, exchange income information. We're going to go back to date of birth for the past 7 years. And that's undisputed. And so that specific order was temporary in every sense of the word, that it was going to be corrected. And so in that sense, Judge Medallo, there's no motion needed.
If you do not oppose that the $200 payment constitutes a temporary order of support, then doesn't that mean that constitute a final judgment as to that order, and that there are limitations under our statute and corresponding case law in which that can be challenged and attacked collaterally in a subsequent period of time to go back and undo it and enlarge it?
Yes, acknowledge that with respect to that particular issue of the retroactive modification, it's a difficult one, especially for the position that we're advancing, which is to affirm Judge Medallo's decision on that issue, which was to limit the modification to this case facts, and it does appear to go against cases like Moylan that says you need to go forward. However, Judge Medallo limited to these facts where otherwise to not allow the retroactive modification again would create an incentive to let's just get an arbitrarily low amount, let it go for years, as what happened in this case, and cannot be corrected. And so I acknowledge it is a difficult position in light of some of the cases such as Moylan, but under the facts of this case and the policy stated in 34105, as well as Palomo, regarding the policies of supporting children and obtaining equitable orders, it's difficult to reconcile those two principles, except to limit what happened in this case.
I was going to ask, in the Moylan case, the issue there seemed to be whether the court still had jurisdiction to modify the temporary order when an appeal was taken from the order. And I thought in that case, the court determined that it did, since it was a temporary order, but capable of being appealed and challenged. And during the pendency of the appeal, the court could then not change the order. I'm not sure that the court ended up addressing the issue of a retroactive modification of a temporary order. So, I'm not sure that the issue has been fully addressed. Is when it's true, the court during the pendency of an appeal can't address the amount of the order. The order is still in effect. There's no stay of it, but it can't modify it during the pendency of an appeal. But when the appeal is completed, I don't think the Moylan case addressed what happens when that appeal is finally disposed of, and whether or not a motion is required to retroactively modify that temporary order.
The portion, and there are several Moylan cases. The one I'm referring to is 2002 Guam 18. And with respect to retroactive, they did address the issue of retroactive application of an order, but only in the context of Attorney Moylan specifically filing a motion to modify. And the court the Superior Court had retroactively applied that to the date of the hearing. Whereas Attorney Moylan argued that should go back to the date of filing of the motion. And so it did address retroactive modification in that sense. However, it did not address whether you can go beyond that to correct any temporary orders prior to a motion to modify being filed. It was
the 18 case.
Yeah.
Did the 18 case involve the final order of support or also address a temporary order? I know the 17 case, which is the one that said it was a final judgment and capable of appeal, was addressing a temporary order. So I'll have to go back and look at the 2002 Guam 18 case and see if that specifically was addressing a temporary order of support or not.
I believe
you cited to section N34119.2. isn't that whole section having to do with establishing paternity? And does it apply to the general adjudication of child support? Or is it just confined to the period of time that paternity is being established?
The statute is it's titled temporary support orders, and it does mention about the pendency of judicial determination of paternity. However, the provisions in subsection C and subsection B, I believe, are equally applicable, because subsection B states that a temporary order of support does not prejudice the rights of a person and child that are adjudicated. And in addition to subsection C, where the temporary orders can be revoked or modified, I would argue that it's not limited simply to pending the judicial determination of paternity. I would state that it provides, at the very least, guidance as to issues such as the one present in this case. That the court can modify or revoke temporary orders. And so,
but doesn't subsection A say the court shall issue a temporary order of support pending and a judicial determination of paternity?
That's correct. And so that section addresses that issue. But I would submit that 34119.2 generally addresses temporary support orders. Generally, not only dealing with pending, otherwise it would state that. Temporary support orders in the case of pending determination of paternity. That's why the statute is divided, subsection A, B, and C. And so it would not be just limited to cases of temporary orders of support in cases pending determination of paternity. Subsection B and C should apply generally to temporary orders, period. And
Thank you.
Yes, Your Honor.
Thank you. That's
going back to the what I would say is the major issue is 34116.1, which is again the basis for a lot of Attorney Wolf's arguments relies on an interpretation that she advances. That is, it's a limitation of 1 year to go non-pro-tonque, and that once an order is in place, you can't go back. And there's been some discussion in the briefing about the history of that issue, that some findings and orders and court decisions, a few have found that to be a limiting provision, and others have said no, under no circumstances is that a limitation provision. But I would like to point out that with respect to 34105 and 34116.1, they address two separate issues regarding back child support. 34105 addresses when you can go back pre-filing, birth to filing. That's that issue. In 34116.1, the issue is when can you go back to the filing of the complaint. So it's two separate time periods. So they are, as drafted, they're in harmony. The only question is, what does 34116.1 mean, which has not been answered yet.
Let me ask you, in connection with the 34116.1 interpretation, can there be more than one date that's relevant? So you have obviously an action for divorce, and there's no order of support that's entered at that time, and then you have subsequently an action for child support. And in terms of determining how far the order can go back non-pro-tonque, is it possible that you could have more than one applicable period depending on what the action is?
It would, two things. First, Your Honor, the statute provides for a previous order for child support, and so that would mean any previous order. And then if there is none, then it will allow the court, if it wishes, because it is a may, not a shall, to go back to the effective date of the filing of the complaint. And I would state that language, filing date of the complaint, is limited to the case before the court. considering which effective date to go on. It's going to be one case. So it can't
So
be
let's look at the facts of this case. So here you have a divorce complaint that's filed in 2009. At the time of the case was filed in 2009, there is no previous order for child support. And so the court could, in that case, enter an order, nunc-pro-tunc to the date of the filing of the complaint, but the court didn't do so, didn't do anything with regards to child support in the complaint for divorce. Then in 2014, there's an action that's filed for child support. At that time, there's still also no previous order for support, right? There's no support that's entered in 2014. So can the court then, in evaluating the nunc-pro-tunc date, what is important for it? Going back to the 2014. So if it takes a year to decide what it's going to enter for support, it can only go back to 2014, or is the court basically looking at the 2009 complaint, so therefore it can never enter a nunc-pro-tunc order going back 1 year, or it's only, or it can, but only for that, looking at 2009. So the period between 9 and 14, it can't enter an order except the total. Whereas if you look at 2014 as being the operative date, then there's no bar under 105 for them seeking recovery for the costs of support, because there's no support order. There's no arrearages to collect. You're going after what is under 105A8, reimbursement for costs of support that weren't paid.
That's correct. So 105 subsection A8 is pre-filing the complaint. And so in this particular case, the action for timing purposes is the 2009 divorce case. And that's because that case, even though it's a divorce case, as mentioned by Attorney Wolf, it did contain a prayer regarding child support. And so it was, in that sense, an action concerning child support, which the Attorney General entered into that existing action in 2014. And in 2014, I believe, was the date of the temporary order of $200. And so, but what I'm advancing is that temporary order of $200, for purposes of 34116.1, is not a bar to go nunc-pro-tunc to the filing of the complaint. It's irrelevant. The fact that it was ordered, and again, it was ordered to allow for payments. It shouldn't be used as a penalty. Instead, you look to when the case was brought. Was there a previous order? There was none. So the court can go back to the filing of the complaint. It doesn't matter that there was a temporary order of $200. And that comports with the decisions of the referee.
I have a difficult time accepting that the order of 200 doesn't constitute a temporary order. And so that's a difficult issue for me. I mean, I understand the arguments about stopgap, about not looking at the worksheet calculation. But, you know, this.
But as far as I understand, Mr. Valdez, it says that the $200 payments did constitute a temporary order of support. I mean, that's how you answered my question.
Well, in his brief, he says he agrees with the judge that it's a stopgap measure and not a temporary order. Because if it is a temporary order of support, then in 2014, when they filed the action looking for child support, and there is a previous order of support in place, right?
So can you clarify for us, Mr. Valdez, what is it that you're contending? Is the $200 a temporary order of support?
For Dalio,
I guess the virtual format doesn't want you to answer that question. You froze, Mr. Valdez, so you're going to have to repeat yourself.
Okay, there you go.
Well, that's a good picture, but I can't hear what you're saying.
is it on my? How about right now? Am I still frozen?
No,
No,
you're
I
good.
apologize. Okay, I apologize. So Judge Berdallo did not say it's not an order. Judge Berdallo's position was it was not a final adjudication of support. It is a temporary order, but it wasn't a final adjudication requiring a motion to modify. And so, as I brought up earlier, if there is a permanent child support order in place, that's different from a temporary order. By its very nature, temporary orders are meant to be corrected, modified, or adjusted.
Yeah, but there is a process and a procedure to do that, and limitations. A temporary order has the effect of, if it's not challenged, number one, it constitutes final judgment. Number two, if it's sought to be modified, is subject to the changed circumstances and the corresponding requirements of 34121. And so it doesn't operate in a vacuum. It has processes and limitations, both by statute and case law. And so we just can't ignore that.
If there is a previous order of support, a temporary order in effect, then you don't have the 1-year limitation, correct?
That's correct, and you can't go back to the filing of the complaint. Right, that's correct.
Yeah, so you can, yeah, so there's nothing that bars you from going back essentially for whatever period you want. You don't have the limitation of the 1 year if the order of support is in place. It's only when there's been no order, they want the court to be able to make its decision within that period of time. Is that the argument you're making?
No, that's not the argument, because that would still result in a limitations period. And so the argument that I'm making is that in accordance with the referee's analysis is that for 34116.1, where there's no previous order, you go back to the filing of the complaint. And again, that is
and what about if there is a previous order?
If there is a previous order, then retroactively you cannot go back to all the way back to the filing of the complaint. You would simply, unless modified, that order would be in place. Now, I do acknowledge that the cases in which a case is brought, a child support case is brought, and there is a previous order would be very unique. And so the result is when a case is filed involving child support for minor children, you go back to the filing of the complaint, which again is what the referee ordered.
But that's based on the policy from the Palomo case, right? Not the statute?
No, it's part of the policies and the case history involving that statute, but also the language itself allows for it to be interpreted in such a way, because again, there's no mention that again, I harp on previous order, not current order, not first order. And again, the beginning as to cases filed after the effective date of this section in any action for child support. Is there a previous order? So it shouldn't be, the language doesn't only allow for one interpretation. And I would state that the interpretation I'm advancing is equally harmonious with the other statutes and also complies with the policies, which Attorney Wolf's interpretation does not.
So, Mr. Valdez, I'll give you an opportunity to wind up. You are over your time period now, but Ms. Lohan exceeded her time. So if you wish to make concluding remarks, allow you to do that.
Very quick, thank you, Your Honor. Just that in this particular case, it was rife with delays, that's admitted, that only benefited Mr. Wilson. And to be clear, what Attorney Wolf's interpretation will result in is an order that for the 65 months between 2009 and 2014, Mr. Wilson would not have to pay any child support. And that cannot be sustained in light of the policies stated in statute and in Palomo and other cases. And on that, I would thank Your Honor for the opportunity to argue.
All right, thank you, counsels. It's been
Your Honor.
Yes.
I'm sorry. I understand. I went over more than 10 minutes for my time, but much of it was answering questions. May I dare to request 1 minute to wind up?
Well, that's the process, and that's how we compute our time. But I'll give you 1 minute, and I'll give Mr. Valdez 1 minute. Any objection, Justice Merriman?
No objections.
All right.
Thank you so much. In this case, there was no delay brought by my client. He filed the complaint. He reignited activity by trying to seek visitation with his son. He's been represented by counsel throughout. The Attorney General, the defendant who never filed an answer, could have taken action to obtain child support from him. The AG's office under Chapter 34 has broad authority to get financial information from obligor parents, including Section 34-109, which grants authority to the AG's office to get financial information from Revenue Tax, from financial institutions, and where they don't comply to subpoena these institutions for the obligor parents and the custodial parents' financial information to determine support under the child support guidelines. And so these are actions. This is delay, not by my client. This is delay by the Attorney General's office. There is more than enough time from the filing of a complaint or an action to get a first child support order. More than enough time to get.
Thank you, Attorney. And Attorney Valdez, you have 1 minute to, if you like, make any concluding remarks.
Yes, just to address that last statement from Attorney Wolf, the decisions on these issues does not require a showing of delay on the part of her client. The statute should not be interpreted to create an incentive for delay. And so if the interpretation that's adopted advanced by Attorney Wolf is adopted, it's going to create these incentives for delay. It doesn't mean there has to be active delay. There's an incentive. Let's get a lower child support amount temporarily and hold it for years. Let's delay the implementation order for years. It's going to benefit obligors. And that's the purpose behind those policy statements and the statute that says parents need to support their children. And so we don't need active delay. It's incentive for delay, which is present in this case. Thank you, Your Honor.
Thank you, counsels. The court appreciates the zealous advocacy that has been presented. We appreciate the importance of this case in this area of the law, and it's a case of first impression, and we will give it every review and examination that the case warrants. And but thank you for your arguments this morning. And with that, the court will take the matter under advisement, and the court stands adjourned. Thank you, counsel.
Thank you.
Good day.